Hi, Miss Agate.
It's Agate.
That's what I said. My name is Matthew Neaton, and I am an associate with Scudder and Robichaux.
Gesundheit.
Anyway, and of course, I am going to be representing you in your current contract claim. I've already gone over the claim a little bit and talked to my paralegals, but before we get started, I'd just like to hear from you in your own words, kind of why we're here today.
Well, as you know, I do run a very successful dog showing business. We have done very well in the past. Most recently, we were at the Westminster show. We did incredibly. You may have seen us on TV.
No.
No? Oh. Well, you're missing out. Anyway.
Okay. Sure I am.
The Boswell family called me at the end of last show season,
Okay.
to show their bearded collie bitch, Becky. Beautiful dog, sweet temperament. She is a champion, and they really felt that my services would best be utilized here because, quite frankly, I'm very good at what I do.
Okay.
So I spent most of the off season preparing for the current spring season, and I got a call about 2 weeks before this season started, and Mr. Boswell said, "I'm sorry, you can't show Becky. Something's come up," and that's all he would say. I'm out of pocket about $10,000 at this point, and they told me that I could be expected to receive $14,000 up front for my services for the show season.
Okay. That's pretty much in line with what the paralegals told me. So I'm going to go ahead and start getting into the facts and into the legal details here on what we can expect. So first off, I have a couple of pictures here. The first one I'm sure you'll recognize. This is the bearded collie class at last year's show, and of course we've got Becky there as the champion. This next one you may not have seen, but my paralegal did. He found out what exactly had happened, and as it turns out, Becky got into a bramble bush at some point, and they've had to shave the dog.
That's a bald bearded bitch.
That is, and not something that's going to win them any points at the shows. I'm not an expert, you are, but even I can tell that. We've done some research into this area of the contracting law, and specifically into the defense that they're raising. So of course we are claiming that they breached the contract and that they owe you money.
They do.
They are claiming a defense called impracticability. What they're saying is that basically the terms of the contract are impracticable or impossible to fulfill. And they're wrong for a few reasons. So we're going to kind of go through that. We're going to talk about that and kind of explain why and what our thought process is going forward. So the theory of impracticability is pretty well established in the law. The most well-known case comes from 150 years old, back in 1863. There was a group of musicians who went to rent out a concert hall to perform a concert. And so the agreement was they would pay £100 to put on this show, and right before they're supposed to put on the first show, the concert hall burns to the ground. Obviously at this point you can't have a concert. So the musicians tried to sue the concert hall owner, saying that there's a breach, and the concert hall owner used this defense called impracticability. Now before this, impracticability had basically only been used if somebody died. So let's say you had an actor who was supposed to play a certain part in a play. That actor dies. Obviously he can't perform in that play. The concert hall owner tried to use this same theory for the building, and the court agreed. They said, because the concert hall no longer exists, it was impracticable. In fact, it was impossible for the concert hall owner to be held liable for a breach. The problem here is this is not a matter of impracticability, because in the concert hall issue, it was the concert hall owner who claimed the defense. In your case, the situation's kind of flipped. So what we have here is, in the concert hall case, you have the musicians who are paying for the good or service, which is the use of the concert hall. In your case, you have the Boswells paying for the good or service, which in this case is you showing the dog. The the concert hall owner was correct that it was impracticable for them to provide the concert hall for the concert. The Boswells are incorrect that it's impracticable for them to pay you. Nothing is stopping them from writing that check. We're going to look at another area of law that's called frustration.
I'm sure frustrated.
Well, frustration in the law doesn't deal with, how you feel or like how I feel, with a pregnant wife who's lost her libido over the last few months. Frustration in the law refers to frustration of purpose. So what that means is basically you pay for something and now it's not worth as much as you thought or hoped it was going to be worth. So in this case, Mr. Boswell is paying for you to show the dog. The dog is no longer show quality. So there's no value in him paying to have the dog shown. Now, I'm just telling you that to give you a basic idea of what frustration means. Because even if he did find a good lawyer who tells him, no, it's not impracticability, it's frustration, I still think we have a very good chance of winning. And the reason I say that is frustration has a whole lot of limitations to it, just like impracticability does. And there is a very well-known case where Safeway Foods was paying a warehouse to hold a bunch of food and merchandise items, and the warehouse burns down. And so Safeway first tries to claim impracticability, just like Mr. Boswell does. The court shoots him down, just like the court will in our situation. They then claim frustration. I don't have to pay because I'm no longer getting a benefit out of the warehouse. And the court says a couple things here about frustration. First, they start to say that frustration only applies when the frustration of purpose is caused by a legal action. Something in the law says it can't happen. This would be like, signing a contract to buy Cuban cigars right before the embargo with Cuba. Now, because it's against the law to bring them in, there's a frustration of purpose, and there's no reason for me to give you the money. That didn't happen in your case. There's no law preventing him from showing the dog. AKC says he can still show the dog, he just won't get any points, in fact. So that doesn't apply to us. The next thing that the court says in this case is that it has to be something that was not foreseeable. In this case, the court seems to say that the fire, the embargo, the protests, everything that happened that kept the warehouse from being valuable to Safeway should have been foreseen by Safeway, and therefore they cannot claim the defense. Now, that's not a bad thing because it makes it really hard to use that defense, which actually works in our favor. The thing here is, was this foreseeable? Now, I would venture to say that it's not very foreseeable because from what I've learned in this brief study, and correct me if I'm wrong, is that when showtime arrives, dog owners are keeping them locked away in almost a quarantine. They don't let them out to run around in bramble bushes for certain. And so it would be unforeseeable that a dog would do so.
He definitely should have kept it on a leash.
And so because of that, it starts to cut back on some of our leeway there. The main victory for us here actually comes in the form of the second restatement of contracts. The case law is great, but we actually have this statutory law, and in section 265 of that statute, or of the second restatement, it actually gives us a loophole here. And it says that if the frustration is at the fault of the person who's claiming the frustration, they cannot claim the defense and they are held to be in breach of contract. So because Mr. Boswell let Becky out and let her get into the bush when, as a dog owner of a champion dog who's been in these shows before, he knew, or at least he should have known, not to let Becky out. And so because he did, he's at fault for whatever happened. So we should actually be in a very good condition there. So he should not be able to claim that frustration. There's one other legal defense that he could claim in the restatement of contracts. And this is in section 263, and it deals with the destruction or deterioration. You'll notice right here that it says that it deals with the specific thing necessary for the performance of a duty. So once again, his duty created in the contract was to pay you. Nothing is stopping him from paying you. And so therefore, he wouldn't be able to claim that as a defense either. So based on this, obviously impracticability is out of the way. Frustration should most likely be thrown out, and destruction or deterioration should also most likely be thrown out. So it looks like we have a fairly good case, and we should be able to come out of this with a win.
I'm definitely glad to hear that.